Hello, and welcome to McKenzie Friend. Today we're going to look at evidence in family law proceedings. This is a very significant subject. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I choose not to seek admission or practice. Therefore, any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Now, evidence and admissibility. Not all evidence that is relevant can be shown to the court. The rules about evidence are complicated. This is detailed in the Evidence Act. Importantly, evidence must be relevant to be admissible. Therefore, inadmissible material could include the material that is not relevant, material that is unfairly prejudicial to a party, or be misleading or confusing, or cause or result in an undue waste of time, and material that is illegally or improperly obtained. Right. Other types of inadmissible evidence include hearsay evidence, opinion evidence, character evidence, past behaviour, and legally privileged information. Firstly, let's look at hearsay evidence. Hearsay is something you heard from someone else that you did not see or hear yourself. So you can't say, Debbie had a conversation with my ex and said this, and then Debbie said to me. That is not admissible. That is hearsay. Now, the only way to overcome that is to actually have Debbie appear before the court to tell the court representations that she did in fact hear or see herself. Next is opinion evidence. Usually witnesses can only give evidence about things they know as fact. So a witness can give evidence on what they saw, but not what they think about it. One exception to this is the evidence of an expert who has qualifications or experience they use to give an opinion. Sometimes you see that parents will say, oh, this parent has done X, Y, and Z, therefore this is parental alienation. Well, that's not true, because unless they're an expert, like either a psychologist or a psychiatrist, they can't give opinion that they know as fact. So it's inadmissible. Character evidence. Now this is a bit of a tricky one. Usually evidence used to harm a witness is inadmissible. If a party uses evidence to show their good character, you may be able to use evidence to show otherwise. So it's usually not a good strategy to try and put character evidence before the court, because what it does allow the other party to attack that character evidence, which may make your client look worse. Also, past behaviour, which we sometimes call tendency and coincidence. How witness behaved in the past is not relevant to the current case, is not usually admissible. However, you may be able to use evidence that show a pattern of behaviour in certain circumstances. For example, you may be able to show evidence of previous instances of family violence if violence is an issue in your case. So you might make allegations of family violence, and you would also detail, protection orders, times the police will call, things like that. Legally privileged information. Now, confidential information that you give to or got from your lawyer, including negotiations or to settle a case, are inadmissible. Things that said at mediation or in family dispute resolution are also inadmissible, because they want people to be able to be open and honest and try to negotiate and give and take. You can't hold it to that person while they're in that negotiation or the settlement. Now, confidential information may be used when the parties agree to the evidence being used, where most of the evidence has already been used, where the information was not meant to be confidential, where the evidence contradicts other evidence given about attempts to settle the dispute, where the case to enforce an agreement made by the parties to settle the dispute. They might have come to an agreement, therefore it's not legally privileged, and you can bring to the court and say, look, we tried to settle, we had an agreement. Unfortunately, the other party has chosen not to honour the agreement. Okay. Expert evidence. Now, this is a type of opinion evidence. So, reports from professionals, expert witnesses, should only be used when the evidence is necessary to sort out an issue and dispute. If you use expert witnesses, it needs to be included in an affidavit. Now, this is the exception for admissibility for expert opinion. A person must have specialised knowledge. If a person has specialised knowledge based on a person's training, study, or experience, the opinion rule does not apply to evidence of an opinion of that person that is wholly or substantially based on that knowledge. So that's the exemption to opinion evidence by an expert. So looking at some case law from Tooth and the Queen, referencing Hunterset and the Queen, the High Court pointed out that 79(1) of the Evidence Act states that the conditions of admissibility. Firstly, a witness must have specialised knowledge based on the person's training, study, or experience. And second, that the opinion must be wholly or substantially based on that knowledge. Like if you have a professor of engineering, the fact that he's commenting on developmental paediatrics is not expert opinion. Expert evidence should be accompanied by a certificate under Section 177 stating the person's name and address, and states that person has specialised knowledge based on his or her training, study, or experience as specified in the certificate, and sets out an opinion that the person holds and that it is expressed to be wholly substantially based on that knowledge. Seeking a 177 certificate is often a good idea if the person's opinion could be inadmissible because perhaps they're acting outside their scope of expertise. They'll be very reluctant to sign that certificate. Now, just a quick comment. It is not uncommon that evidence is misrepresented as expert opinion in family law proceedings. Often the court, its officers, parties, or practitioners are oblivious or reckless that such evidence cannot be relied upon. Therefore, it is important to seek the 177 certificates to verify the validity of such evidence. With regards to medical evidence, check to ensure the practitioner has the requisite qualifications and is acting in accordance with generally held expert medical guidelines. Check the guidelines with the National Health and Medical Research Council and relevant professional organisation. It is preferable that your GP is the gateway for all health issues and provide any necessary referrals. From a little bit of personal experience, psychologists are notorious for acting outside their scope of expertise. Right. Now, family law is a little bit different when it comes to admissibility of evidence. It's a little bit more, as you can see in section 69ZN. The fifth principle is that proceedings are to be conducted without undue delay and with as little formality and legal technicality and form as possible, which means they're willing to admit evidence that may be inadmissible, then decide whether or not to discard it or set it aside or adjust whatever way they see fit. So, now under the Family Law Act, there are exemptions to the rules of evidence. When considering the best interest of the child are paramount, the court has a wide discretion to admit or not admit evidence. Generally, the court admits everything, then decides what significance or weight to apply. Now, looking at family law rules, Rule 1.08 imposes a responsibility of parties and lawyers in achieving the main purpose, which includes Rule 1.08.1J, which limits evidence, including cross-examination, to that is relevant and necessary. In Rule 15.09, an affidavit must be confined to facts about the issues in dispute and confined to admissible evidence. Now, it's important when you're writing an affidavit that you stick to facts, not do speculations, not draw conclusions, and try and make sure that the material you put forward is admissible in accordance with the Evidence Act. Under Rule 15.13, the court may strike out the objectionable material if it is considered inadmissible, unnecessary, irrelevant, unreasonably long, scandalous, or argumentative. If the court orders material to be struck out of an affidavit, the party who files the affidavit may be ordered to pay the costs thrown away of the other party because of the material struck out. Now, in family law rules, Chapter 15 sets out the rules about evidence generally and in relation to children, affidavits, subpoenas, assessors, and expert witnesses. Evidence adduced at a hearing or trial must be admissible in accordance with the provisions of the Act, the Evidence Act, and these rules. Subject to 69ZT to 69ZX of the Act, apply to a case to which Division 12A, Part 7 of the Act applies, which is pertaining to children. So, these exceptions to the Evidence Act can be found in 69ZT. It's rules of evidence do not apply unless the court decides. 69ZV, which is evidence of children, and 69ZW, evidence relating to child abuse or family violence, and 69ZX, the court's general duty and powers relating to evidence. So let's look at 69ZT. The rules of evidence not apply unless the court decides, and it specifies what part of the Evidence Act don't apply. Of course, relevance and inadmissibility of not admissible material that is admissible because it's legally and properly obtained, still apply. Now, as you see in 69ZT, the court may give weight such as it thinks to evidence admitted in the consequence of provision. Now, it's possible to actually get round the inadmissibility issues of the Evidence Act, because the court may determine that the material, although inadmissible, the probative value will outweigh the failure to abide by the Evidence Act. However, this also must be counteracted with to ensure that the other parties' proceedings aren't prejudiced or they're denied procedural fairness. So when they look at that, they look at the importance of the evidence in the proceedings, the nature of the subject matter in proceedings, the probative value of the evidence, and the powers of the court, if any, to adjourn the hearing, to make other orders, to give direction in relation to the evidence. Now, let's have a look at Maluka and Maluka in 2012, where Justice Coleman stated, to proceed in reliance upon evidence which would not be admissible but for section 69ZT1 is, in the court's view, likely to be mischievous and not just for one party. So it is always best to try and put forward evidence that is admissible under the Evidence Act. And you would be very careful if you would try to use 69ZT1 to put in inadmissible evidence. Now, the evidence of children. Often children aren't necessarily party to proceedings. Their views are usually brought forward by either the family report writer or the ICL, and this very much depends on the age of the child, and so they can determine whether or not their views can be given weight to. So we'll just skip that part because it's a bit tricky. And then also evidence relating to child abuse and family violence. Now, this allows the court to call upon, state or territory police or anything like that, or Department of Community Services reports and things like that. Now, under 69ZX, the court's general duty and powers relate to evidence. And this is where they actually look at how the evidence can be used and how they decide how it should be applied. So, in conclusion, you should ensure that you can find evidence to the issues in contention. It is preferable that all evidence is admissible to avoid challenge of admissibility and the material being struck out, and only seek to admit evidence that would otherwise be admissible if the probative value outweighs the prejudice proceedings. And ensure that any expert is compliant with Section 79 of the Evidence Act and tendered with a Section 177 certificate in support. And avoid any material that is irrelevant, confusing, illegally or improperly obtained. I hope this helps.